All right, for anyone out there prepping for the Queensland Bar exam, there's a tool in your procedural toolkit that you absolutely have to master. I'm talking about summary judgment. It is, without a doubt, one of the most powerful weapons you can wield. So today, we're going to break down exactly how it works under the UCPR.
I mean, that sounds almost too good to be true, right? But that is precisely what summary judgment is for. It's not some tricky loophole. It's a strategic mechanism that's actually built into the system for efficiency and, well, for justice. It lets you wrap up a case early when the outcome is just plain obvious. And knowing how and when to use it, that is a total game changer.
So, to get you absolutely exam ready, here's our game plan. We're going to look at what summary judgment actually is, then we'll dive deep into the core two-prong test. We'll cover how it works for plaintiffs, how it works for defendants, figure out when a trial is still needed, and finally, we'll talk about the court's ultimate final discretion.
So what is this thing, really? At its heart, summary judgment is all about efficiency. It's a filter designed to weed out the cases that, frankly, have no business going to a full-blown trial. It saves everyone a massive amount of time, stress, and, of course, money.
Okay, now we're getting to the absolute heart of every single application, the two-prong test. Get this right, and you're in with a shot. Get it wrong, and, well, your application is dead in the water. Everything hangs on this.
On the face of it, the test looks pretty simple, but you have to prove both parts. First, you've got to convince the court that the other side has no real prospect of winning. And second, because of that, there is absolutely no need for a trial. If you miss one of those, the whole application fails. So, the big question is, what on earth does no real prospect actually mean?
Luckily for us, the courts have given us a pretty clear definition. And for your exam, the case you have to cite is Salcedo. The test isn't whether the case is doomed to fail, it's about whether its chance of success is realistic as opposed to just fanciful. You know, a claim based on wishful thinking or pure fantasy, that has no real prospect. That's the bar the court sets.
But, and this is a huge but, a critical warning comes with this power. The High Court in Spencer v. Commonwealth made it crystal clear that knocking a case out summarily is a very serious step. It has to be done with extreme care, because taking away a party's fundamental right to a trial is something the courts do not take lightly. You really have to show a high degree of certainty here.
Okay, let's put you in the plaintiff's shoes for a moment. You've filed a rock-solid claim, and the defense that's just come back is, well, it's hopeless. Rule 292 is your ticket to a swift, early victory.
But hold on, there is a very strict procedural gate you have to go through. As the plaintiff, you can't just jump the gun and apply for summary judgment right away. You have to wait for the defendant to file their notice of intention to defend. And listen, the case of Vantage Holdings confirmed that a conditional notice is not good enough. It has to be an unconditional one.
Now, let's flip the script. Let's say you're the defendant, and you've just been served with a claim that is completely and utterly without merit. Rule 293 is the perfect mirror image of 292. It gives you the power to apply to have the plaintiff's case knocked out before it even gets off the ground. And you can see the beautiful symmetry here, can't you? The perspective changes, but the legal test, it's identical. For a plaintiff, it's about the defendant having no real prospect of defending. For a defendant, it's about the plaintiff having no real prospect of succeeding. All that crucial case law, Salcedo, Spencer, it all applies equally no matter which side you're on.
But even if you can prove the other side's case has no real prospect of success, you're not home free. You still have to clear that second hurdle, proving there is no need for a trial. And honestly, this is where a lot of these applications come unstuck.
So a trial might still be necessary for a bunch of reasons. If there are major facts in dispute that really need a witness to be cross-examined, well, summary judgment is off the table. As the court found in Miles v. Bull, if there are fishy circumstances that just demand a proper investigation, you need a trial. Same goes for really complex or technical cases, or if a key witness can't be found, or even if it looks like a defense might become available down the track. These are all classic situations where a judge will say, nope, we need to hear this out in full.
And that brings us to the final hurdle, the last piece of the puzzle. Because even if you manage to satisfy both prongs of the test, a win is still not guaranteed. This here is the ultimate backstop. The word may in the rules, that little word is everything. The court may give judgment, but it doesn't have to. As the case of Bolton Properties confirms, the court always keeps a final overriding discretion. If, for whatever reason, it just doesn't sit right in the interests of justice, the court can refuse the application, even if you've technically met the test.
All right, let's boil all of this down for your exam notes. Let's do a rapid-fire summary. 1. It's a two-pronged test. No real prospect and no need for a trial. 2. No real prospect means it's not fanciful. Cite Salcedo. 3. The power is used with caution. Cite Spencer. 4. Don't forget that critical procedural trigger, the notice of intention to defend. 5. A trial might still be needed if there are factual disputes. And finally, 6. The court always has that final overriding discretion. Nail those points, and you are in a very good spot.
And that leaves us with one final big-picture thought to chew on. This power, summary judgment, sits right at the tense intersection of two massive competing principles. On the one hand, you've got the UCPR's goal of an efficient, cost-effective justice system, and on the other, you have the fundamental, almost sacred right of every person to have their day in court. Getting that balance right, well, that's the constant challenge, and it's the very soul of this rule.